GSII Polity Bill/Act. Protect critical personal data of citizens. Draft Bill. The Draft Personal Data Protection Bill, 2018, submitted by the Justice V.N. Sri Krishna-headed expert panel, has proposed that critical personal data of Indian citizens be processed in centers located within the country. The draft law, which comes after a year-long consultation process, however, has left it to the government to notify categories of personal data that will be considered critical. Other personal data may be transferred outside the territory of India with some riders. However, at least one copy of the data will need to be stored in India. The draft bill, which India hopes will become a model framework for personal data protection for the world, will apply to processing of personal data within India, including the state. For data processors not present in India, the Act will apply to those carrying on business in India or other activities, such as profiling, which could cause privacy harms to data principals in India. The draft also provides for penalties for the data processor as well as compensation to the data principal to be imposed for violations of the data protection law. It has suggested a penalty of Rs. 15 crore, or 4% of the total worldwide turnover of any data collection/processing entity, for violating provisions. Failure to take prompt action on a data security breach can attract up to Rs. 5 crore or 2% of turnover in penalty. Personal data, the draft law states, may be processed on the basis of the consent of the data principal, given no later than at the commencement of the processing. It added that processing of sensitive personal data should be on the basis of explicit consent. The law, the committee said, will not have retrospective application and will come into force in a structured and phased manner. The draft bill, which has recommended that a data protection authority be set up to prevent misuse of personal information, also provides for setting up an apparent tribunal on right to be forgotten. The draft states that data principal will have the right to restrict or prevent continuing disclosure of personal data by a data processor. GSII Polity Bill/Act. Handle children's data with care, says committee. The Justice Sri Krishna Committee on Data Privacy has made specific mention of the need for separate and more stringent norms for protecting the data of children, recommending that companies be barred from certain types of data processing such as behavioral monitoring, tracking, targeted advertising and any other type of processing, which is not in the best interest of the child. The committee noted that, at present, there were two types of entities processing the personal data of children. The first type were services offered primarily to children, such as YouTube Kids, Hot Wheels, and Walt Disney, and the second were social media services such as Facebook and Instagram. The committee recommends that the Data Protection Authority will have the power to designate websites or online services that process large volumes of personal data of children as guardian data fiduciaries. The committee noted that this approach, of placing the onus of properly processing the data of a child on a company, is preferable to the existing regulatory approach which is based solely on a system of parental consent. The dominant criticism against parental consent is that it is prone to circumvention, as it risks encouraging children to lie about their age, without achieving the intended purpose of protection, the report said. GSII Polity Bill/Act. Data Protection Authority will be sector agnostic. The Justice Sri Krishna Committee, in a report and a draft bill, recommended the creation of a data protection authority that will be in charge of ensuring that entities processing data do so in keeping with the law. The DPA, the sector agnostic body, will ensure that every entity that handles data is conscious of its obligations and that it will be held to account in case of failure to comply, the report said. The authority will be governed by a board consisting of 6 full-time members and a chairperson appointed by the Union government on the recommendation of a selection committee. The selection committee shall consist of the Chief Justice of India or her nominee who is a judge of the Supreme Court of India, the Cabinet Secretary, Government of India, and one expert of repute who has special knowledge of and professional experience in areas related to data protection, information technology, data management, data science, cyber and internet laws and related subjects, the report said. The DPA members will have a 5-year term, subject to a suitable retirement age, and their salaries will be prescribed by the central government. Broadly, the DPA will have 4 departments and related functions: monitoring and enforcement, legal affairs, policy and standard setting, research and awareness, and inquiries, grievance handling and adjudication. The DPA will be stating codes of practice, conducting inquiries, and issuing warnings.